Hello, everyone. John Worden here. I'm a partner in Venable's San Francisco office, and thank you for attending. So, I'm here to talk for an hour about everything I know about arbitration, or at least most of it. Uh, there are 400 people signed up for this, which is about 395 more than I thought would sign up, but thank you for joining us. I would love to have this be more of an engaging process. If people have questions, comments, unfortunately, we can't do this in a Zoom format because so many people signed up. But if you have questions, you have comments, you disagree with me, you think I'm full of it, just put it in the chat and it'll get to me and I will try to answer them in real time. We'll have time at the end too, but I'd rather answer them as they come. A little more interesting that way. So why am I giving this? Well, I don't know everything there is to know about arbitration or jury trials, but I do know a fair amount. I've tried 60 jury trials. I'm a fellow in the American College of Trial Lawyers. I'm also chair of the San Francisco Bar Association's arbitration section. I've had a couple hundred arbitrations, but probably 25 to 30 actually went to hearing or trial. So I know a little bit about the differences of them. And they are very different processes. And if there's a theme that I have today, first of all, I hope it doesn't sound like a rant about all the things I don't like about arbitration, because I do like arbitration. I just mentioned I'm chair of the San Francisco Bar's arbitration section. Arbitration, for a lot of cases, is the best way to go. It is often faster, cheaper, and perfectly suited for a lot of our clients. Unfortunately, that's not always the case. Uh, the courthouse would be much better for many of our clients, but there is a certain prejudice I found over the years about being in front of a jury. Uh, People think juries, runaway juries, these crazy jurors, who would possibly leave their fate in the hands of 12 people too stupid to get out of jury duty. Well, I'm just going to stand up for jurors for just a minute. First of all, jurors may not have the subject matter expertise that an arbitrator will have. That will usually be the case. But most jurors do want to do the right thing. Jurors who really don't want to be there will usually find a way to say something about something to get themselves kicked off the jury. If the judge doesn't kick them off for cause, one of the lawyers, in particular the plaintiff's lawyer, will kick them off because no plaintiff's lawyer wants to have somebody on the jury who really doesn't want to be there. So most jurors either want to be there, although you got to be careful about the ones who want to be there a little too much. They either want to be there or have accepted some sort of notion of civic duty to take their turn and contribute to the jury system that they may need someday. So jurors do want to do the right thing. Very importantly, if they don't do the right thing, we have judges who can fix it. And if the judge doesn't do the right thing, we have appellate courts that can fix it too. And unfortunately, almost none of that is available in arbitration. And that could be a good thing. It could be a bad thing. It's just different. So I often counsel clients, be very careful about putting arbitration clauses in your agreements. Sometimes you'd be better off not doing arbitration. And sometimes if you do have an arbitration clause, I really don't like the ones that just say, if there's a dispute, we go to arbitration. Those are more trouble than any of the others. If you're going to have an arbitration clause, have some rules. Pick the rules. All the groups, AAA, JAMS, you name it, they all have different kinds of rules, or you can structure the rules to keep it faster, cheaper. Otherwise, a lot of times you'd be better off in the court system. So anyway, uh, next slide, please, Esther. Thank you. My colleague Ashton's going to help do the slides today. Thanks. And there are lots of areas where arbitration is very commonplace. Lots of commercial cases, construction cases, employment, reinsurance, disputes between insurance companies, securities. There's a whole system in the securities area, the rules of FINRA, FINRA is it's for when usually, not always, but usually when customers of your larger brokerage and investment firms are not happy with how their account was handled, they go through the FINRA system. Uninsured motorists, there are many areas where this has worked very successfully for a long time, and worked well. But let me just explain what arbitration is for a moment. Sometimes people confuse arbitration with mediation. I know a lot of people who signed up are very sophisticated. You know this, but not everyone. Uh, Arbitration and mediation really have nothing in common with each other, other than they are two different ways to resolve a case, other than going through a jury trial. A mediation is a glorified meeting. It's a glorified get together, completely non-binding. It's considered to be confidential. There's privileges out there that say when you go to a mediation, almost anything you say at the mediation cannot be held against you at an arbitration or at court. Otherwise, though, you don't like the way it's going, you can get up and leave. Very informal in most cases. Unless the parties agree to a deal, in which case then it's binding, but otherwise it's like it never happened. Arbitration is very much the opposite. And arbitration is like a trial. It is a trial, except instead of it being in the courthouse in front of a judge and jury, it's usually in a conference room with one or three arbitrators. There are oftentimes opening statements, or at least opening briefs. Witnesses are called, they are examined, they're cross-examined. Expert witnesses testify, they are examined, cross-examined. There are closing arguments, sometimes there are closing briefs, and then the arbitrators render a verdict. And that verdict, often called an award, is not only binding, it's much more binding than a verdict from a jury. And we'll talk about that in a moment. So it's not a bad thing that it's very binding. If you want finality, this is a good place to go, arbitration, but you should be aware of that. If something goes wrong, the options are limited. Next slide, please. So the benefits of arbitration, it's supposed to be faster. It's supposed to be cheaper. It's supposed to be streamlined, very final. And here's a couple that really are good reasons to be in arbitration. You can have very subject matter intensive, highly technical subject matter addressed by an arbitrator or arbitrators who are experts in that field. That's definitely a selling point. For example, construction. You have a construction case in front of a jury. Somebody on the jury may know something about construction, but most of them will not. On the other hand, a construction arbitration will almost always be in front of a lawyer who has a lot of construction arbitration experience, or potentially people who are employed in the construction field. And that's great. You can skip a lot of steps. You don't have to spend a lot of time explaining what a subcontractor is or a change order, because the arbitrator will know these things. Confidentiality, that's another benefit. Not all arbitrations are confidential, but if you want to keep them confidential, it's easier to do that. And whereas a jury trial, anybody can walk into the courtroom and watch. Not anybody can walk into a conference room at JAMS, AAA, ADR services, and watch. So it's easier to keep things out of the public eye if that is a concern. But let's talk about these for a minute. Is it always faster? Is it always cheaper? Is it always streamlined? Those we can debate. Next slide, please. So I'm just going to give some comparisons between how arbitration works and how a jury trial works. So an arbitration lawsuit gets filed. When a courthouse lawsuit is filed, if, for example, the claims are barred by law, the defendant can go into court and immediately file a motion to dismiss. California, sometimes in state court, they're called demurs. You can dismiss on the grounds these claims are not valid. They're contradicted by the law. They're contradicted by their own allegations. They're contradicted by the documents attached to the complaint. Any of those could be valid reasons to have the judge rule this case is out of court before we ever get started. We don't need a jury. For example, let's take a simple case. Statute of limitations for auto accidents in California is 2 years. If someone files a lawsuit in February of 2025 and they say, I was involved in an auto accident and the auto accident took place in 2022, the defendant can immediately move to dismiss, say this accident took place 3 years ago. Their own allegations say it. You should dismiss the case, throw it out of court, and the judge can do that. And that's the end of the case. That almost never happens in arbitration. One of the only grounds to appeal an arbitration is where the arbitrator refuses to hear evidence. In other words, the arbitrator refuses to hold hearing. So almost every arbitration is going to go all the way to the arbitration trial. So if you have the kinds of cases where you're getting sued and there are cases that really should be dismissed, they're contradicted by the law, they're not meritorious. The courthouse, you can get that relief. You can get claims dismissed. Arbitration, not only is it almost impossible, arbitrators are taught, and the arbitration appeal rules tell us, always err on the side of allowing an arbitration trial. So once an arbitration is filed, getting it dismissed at the pleading stage is almost impossible. One other impediment to getting cases dismissed early is you don't have an arbitrator. Once an arbitration is filed, there is generally not an arbitrator assigned. Therefore, someone has to appoint the arbitrator. There are detailed selection processes for how to, excuse me, I just lost my question page. I'm just going to try to pull that up here. I don't see it, but I guess it'll come back if it does. Anyway, someone has to get the arbitrator appointed, and that's a lot of work, and you got to spend a lot of time on it because arbitration rulings are usually not appealable. So what happens is the arbitration gets filed. There's no chance to move to dismiss because there's no one to move to dismiss to. There is no arbitrator assigned. Therefore, it is important at the beginning of the outset of the case that an arbitrator get assigned, and there's detailed ways to do that. The arbitration services, let's just say it's JAMS, they'll send you 9 arbitrators. Each side should do research on each, and each side gets to strike, let's say strike 4, and the remaining one is the arbitrator. Well, you've got to spend a lot of time looking up prior work they've done, calling around, emailing around, and finding out who you want to pick, and that is time consuming. But once it is done, the arbitrator, once they're assigned, they are still not going to grant a motion to dismiss. It's almost unheard of. Someone sent a question, and I'll answer these as we go. Good question. How can I become an arbitrator? So I've never been an arbitrator, and I like being an advocate, and I'm not sure I would be very well suited to be a neutral, to be the person in the middle. There are lots of training areas. Almost anybody can be an arbitrator. You don't have to be a lawyer. You don't have to be a judge. You don't have to be experienced in an area. Almost anybody can be an arbitrator. If the parties agree to use someone as an arbitrator, they're the arbitrator. So anyone could do it. Having said that, most arbitrators are retired judges or litigators, trial lawyers who have been around the block for a few years. people with strong subject matter expertise in certain areas, like someone who did construction law for 30 years would be a good person to be an arbitrator for a construction case. And there are lots of training services out there where you can go get trained, uh, dozens of hours of training to be qualified to do it. And then you can join one of the services, JAMS, ADR services, Judicate West, AAA, but anybody could do it. There we go. Next slide, please. Discovery in an arbitration could mean anything. And this is a big deal. If you really want to have the benefits of arbitration, faster, cheaper, streamlined, make sure you have an arbitration with defined rules. One thing I like about the FINRA arbitrations, these are the securities arbitrations, and they're not small cases. Some of them could be small cases, but they could be big cases. I had an arbitration recently in Nevada against an owner of a Major League Baseball franchise, and it was a big deal, dozens of millions of dollars. But they have rules, and one of the rules is no depositions, period. Now, most of us who are litigators and trial lawyers get very nervous when we don't get to depose people, and rightfully so. The first time I saw the plaintiff or claimant in that case, nice gentleman, was when he showed up to testify. I never deposed him. Therefore, I have no deposition transcripts to look at to help prepare my cross-examination, but that works both ways. The other side wasn't able to depose my people. That actually, depending on the case, is not a bad system, because in a lot of cases, we lawyers like to be very prepared. And one way we like to do that is to depose everybody we can imagine who might have anything to say about the case, and plenty of others who might not. So dozens of depositions in a case, all of those cost money. Every transcript now is over $1,000. And the lawyer time, 7 hours of depo time, 14 hours of prep time per deposition, that adds up in a big hurry. And when you're in the courthouse and unlimited depositions, it is very, very costly. So one thing I like about arbitration is either the rules limit them or an arbitrator can limit depositions. For example, a lot of the rules for the different groups, AAA has lots of different rules. They have different rules for employment arbitrations, construction arbitrations. And some of them provide you get one deposition per side. I kind of like that. I like getting one deposition. You can only get so much out of the pleadings and exchanging the documents. And arbitration in general is very light on written discovery, interrogatories, requests for admission. So it's nice to have one deposition to get a feel for what's really going on, or a small number. Most good arbitrators will work with the players on both sides to limit it. If everybody will agree, if you both agree, you get 3, okay, great. If you can't agree, arbitrator will order you each get 2 aside, something like that. But the courthouse, the federal rules are very clear about who can be deposed, when they can be deposed. So this isn't just a matter of trying the arbitration and litigating the arbitration, but also careful consideration of what rules to apply. So if you're drafting arbitration clauses, if you think arbitration's best, I would give serious thought to making sure the clause is specific. Either it refers to a specific set of rules that says how many depositions you get, how much time you get, etc., or it references a particular set of rules, such as the AAA employment rules, that specifically define how many depositions you get. Otherwise, discovery is expensive. Most cases don't go to trial. I started by talking about all the cases I've tried. Still, most of my cases settle. And in most of my cases, we spend tons of time in discovery. That's where the vast majority of time is. If you want to save money, streamline things faster, cheaper, get rid of a lot of that. If you're going to allow full-blown discovery, as many depositions as anyone wants, as many written discovery requests as anyone wants, just be in the court system where there are rules. There are appellate decisions, there are federal district court decisions that say what you can do in a deposition, that say what kind of written discovery you can have. So if it's going to be full blown, no limits at all, just be in the court system. It's going to cost the same for the deposition and arbitration of the court system costs the same amount of money. But at least if you're in the court system, if there's a problem, you've got a judge who's got rules to look to tell us how to guide our decisions. So we have a couple other questions. Do statutes of limitation apply to subject matter submitted to arbitration? They should apply. Yes, underlying substantive law should apply. Having said that, it can get a little complicated. For example, the FINRA rules specifically say no case is eligible for arbitration more than 6 years after a securities transaction. Statute of limitations for securities fraud in California is 3 years. So is it 3 years or it's 6 years? Sometimes the rules try to provide other statute of limitations. They should not supplant the underlying substantive state law on statute of limitations. But I will say it's a good question, and there's a lot of debate about that. The next question, what is your opinion on using arbitration for wage and hour disputes? Most of what I say here would apply to wage and hour disputes too. So I think arbitration could be very good for wage and hour disputes. The problem is class action arbitrations. A lot of these are now class actions. Class action arbitrations are very difficult to have. I've heard of such a thing. I've heard of class action arbitrations, but I've never had one. It'd be very unwieldy to handle that with an arbitrator as opposed to a sitting judge. The rest of it, some reasons most employers like to have arbitration, like to have employment disputes in arbitration to the extent California law still allows that, at least in California where there have been a lot of legal developments there, is that you can keep it confidential. Whether the employee's dirty laundry, the employer's dirty laundry, it's supposedly going to stay confidential in the conference room where the arbitration is. But most of my comments, the pros and cons, would be apply to labor and employment as well as others. Next question, arbitration, what mechanisms are available if a counterparty refuses to produce documents that are likely in their control? Well, that's the arbitrator. The arbitrator can order it. And the same rights apply to an arbitrator as opposed to a judge ordering production. And the thing about an arbitration is if you tick off the arbitrator, you don't follow the orders. The arbitrator is your judge and jury and appellate court. So if the arbitrator says you better turn those over, you better turn them over. Obviously, if a sitting judge says the same thing and you don't listen to a sitting judge, bad things happen too. So I'm not sure there's much difference with regard to that question. Next slide, please. Motion for summary judgment. Very common in court cases. Motion for summary judgment, just a reminder, is it's where there have been depositions, there's been discovery, and someone has, one side has concluded, Your Honor, in court, this case is so black and white. We don't need a jury to sit here for a month hearing all of this testimony. You should summarily adjudicate this. Everyone agrees on these facts. There's no factual dispute. We just disagree on the legal significance of the facts. Well, one or more, either side can file a summary judgment motion. And the judges grant them sometimes, not always, but sometimes they do. almost never is that going to happen in an arbitration. For the reasons I said earlier, the Federal Arbitration Act and the relevant state arbitration acts that follow it, they almost all say one of the only grounds to appeal is failure to allow a party to present their evidence. And if you're summarily adjudicating that someone's case is over, either against the plaintiff or the defendant, that party has not had their day in court, if you will. They've not had their day in the arbitration hearing or arbitration trial. Therefore, they can appeal. So we all know somebody who had that one time they won that one summary judgment motion. I follow the national results to the extent they're not confidential pretty closely. And every now and then I'll see somebody will win one, or I'll hear about it, win a summary judgment in arbitration, but it is very, very rare. It's rare in court too, but you're way more likely to get summary judgment in court. So if, let's say you're a defendant, you keep getting sued for claims that you think are specious, that don't have a lot of merit, the courthouse is the place to get summary judgment on these. Judges, there's rules. California, the federal rules, they have specific rules say the court must grant summary judgment if there are no facts in dispute. There's no such rule in arbitration. So it's something to think about. Okay, the next slide, please. While we're looking at those, there's a question. Any suggestions regarding mass arbitration and drafting arbitration clauses to protect against mass arbitration? There's a lot been written on that. Most of the securities firms came out with class action arbitration waivers. I'll just give a couple comments. Those have been held to be enforceable in many instances. Here's the flip side of that. If you don't like one class action, what could happen is, and I won't cite specific cases here, but there have been rideshare cases and related where, because the courts held that those class arbitration waivers are enforceable, the plaintiff's lawyers just had hundreds of people file individual arbitrations. Now the employer has to pay arbitrator fees, and those judges don't cost any money. Arbitrators you have to pay, and they're not cheap. Now all of a sudden they've got 500 individual arbitrations, 500 fees they have to pay to 500 arbitrators, including their own lawyers, instead of one class action. So be careful what you wish for. Just it's a balancing here. The rules of evidence. So in court, there are detailed rules of evidence. I've tried cases in probably 15 different states. All states have rules of evidence. The federal rules, of course, have rules of evidence. And of course, in court, the most important objection is usually relevance, and it's meaningful. Irrelevant evidence is inadmissible in court. All the rules say that. And judges, if they're on the ball, will do their best to sustain objections to keep out irrelevant evidence. Most parties file extensive motions in limine before a jury trial. These 27 things should not be said in the trial in front of the jury. They're not relevant, and judges grant those. So the trial, in a perfect world, is much more streamlined in front of a jury because only relevant evidence can be admitted. The judge can exclude areas of questioning. The judge can exclude witnesses in their entirety. I don't think this witness is on point. I'm not going to let any testimony come from this witness, and I'm not going to let any other witness talk about these 7 issues. No such thing in arbitration. Indeed, it is just the opposite. Rules of evidence. FINRA, the panel is not required to follow state and federal rules. JAM, strict conformity to the rules is not required except with privileges. AAA, conformity to legal rules is not necessary. They all say basically the same thing. So unfortunately, in an arbitration, for better or fortunately, depending on how you look at it, almost every issue comes in. There's testimony on every issue you could imagine. There's almost no such thing as a motion in limine in an arbitration. I know there are some, people do file them, but of course, the person you're filing the motion in limine with is the arbitrator who is hearing the evidence. So let's say you've got some scandalous topic that you really don't want the jury to hear. It has nothing to do with the dispute. I'm just making something up. The plaintiff had a DUI arrest recently. In court, you file a motion to eliminate judge. We don't want anyone telling the jury about the DUI arrest. The judge will grant that. Nobody can tell the jury. If somebody raises it, it's a mistrial. Here's the problem with motions in limine in arbitrations. The person who's hearing the motion in limine is the arbitrator. So you're asking the arbitrator not to let anybody talk about the DUI. And by raising that, you're now telling the arbitrator all about it. So you're kind of stuck. So motions in limine can be, even if the arbitrator entertains them, there's only so much you can do. Question, what is the best jurisdiction state for arbitration? Does it matter? Most arbitration clauses will tell us where they have to go, and there are many different providers. It's an interesting question, which state is best? I don't know how to answer that. Every arbitrator is different. And I will say that we're all colored by our past performances and results. Arbitrators that ruled in my favor, I thought they were great. Arbitrators that ruled against me, I don't think of them as being as great because I've got sour grapes. Things didn't go my way. Whether it's state to state, I have had arbitrations in probably a dozen states. I can't say that one's better than the others, but the rules, and I'm not going to get into it in this program. I would be happy to talk offline about different thoughts I have about JAMS, AAA, Judicate West, Signature, ADR services. But I will say this, for all of them, the group is not as important as the individual arbitrators. All those ones I just named have great arbitrators. Find a great one. Find someone that is respected, who is reasonable, even if the rules of evidence don't apply explicitly. Somebody who at least understands the reason why we have these rules. And that's something I try to do when I'm in an arbitration and a hearing. You kind of look foolish in an arbitration if you make a lot of objections, because everybody knows it's arbitration, and I just showed you all these rules. They all say the rules of evidence don't apply. But I will make objections now and then, and I will do so with some sort of a little speech, which is impermissible in court. And the arbitration objection will usually say something like this. Miss Johnson, our arbitrator, I know this is arbitration, and I've been trying not to object, but the last 10 questions have all been leading. Could we please have the witness testify and not the lawyer? Or Mr. Smith, our arbitrator, this is all hearsay, and I'm trying not to object. I know it's arbitration. But everybody knows that the witness is talking about something someone said, and that someone will never be testifying. You should exclude it. And I think by making my little speech, again, those speeches like that are very impermissible in front of a jury. But in arbitration, there's no jury. I think sometimes arbitrators do, at least even if they overrule it and allow the questioning, they factor it in. But strict conformity is not required. It's time I'm to remind you that the CLE code is Arbitration 2025. Arbitration 2025, no space. Next question, must an arbitrator adhere to the federal rules on privileged communications and reject requests for documents between spouses and attorneys? Yes, they are supposed to. It says right here that JAMS rule, strict conformity is not required except the arbitrator shall apply applicable law privileges. And that is one thing that arbitrators should do and do. Whether there's a spousal privilege, attorney-client privilege, those generally apply just as they would in court. Okay, let's go to the next slide, please. So I've alluded to this a little bit, which is um, all the groups have great arbitrators, but not every arbitrator, in my opinion, is a great arbitrator. Um, they're human beings, just like lawyers, just like jurors. We'd like to think that all arbitrators are learned scholars of the law with great judgment, great attention span. Uh, and that's true a lot of the time, but it's not always true. I'm not always perfect. Our arbitrators are not always perfect. Jurors are not always perfect. So it's very important to select a good arbitrator, someone who's fair. And there are ways to do that. As soon as the arbitration is filed, as I mentioned, there's no arbitrator. Unless the parties have already agreed in advance, we're going to use arbitrator Smith. That's very unusual. Usually, someone files with one of the groups I've mentioned. And then if they can't agree on someone, the group sends out a list of arbitrators to select from. It's very important at that point to send emails to all your friends, all your colleagues, your coworkers. Here, every day here at Venable, we get an email from someone saying we've just been assigned these 5 potential arbitrators. Has anyone ever worked with them? And it's very important to find out as much information as you can. One thing I like about these FINRA securities arbitrations, they're not confidential. The rulings are published on the FINRA website, and they're very detailed, who the arbitrators were, who the witnesses were. Was it for the defense? Was it for the plaintiff? Were punitive damages awarded? And there are services out there who will track all this. And when you get the arbitrators list, you can go to those services and they'll send you a printout and a report on everybody on the list. Arbitrator Jones had 27 arbitrations, ruled for the plaintiff 22 times, awarded punitive damages 14 of those times. Arbitrator Johnson had 14 arbitrations, ruled for the defense every time except one. You can get a feel for who you're dealing with here. Are they someone who uh, routinely rules for the plaintiff, for the defendant? And that's something you can't really do with a jury. You can't really do with some arbitrators in different fields. But the FINRA setup, if you have securities arbitration, there's a lot of information out there. It costs money. Almost everything costs money in arbitration. You got to pay the arbitrators, you got to pay these services, etc., and you still have to pay the lawyers to handle the case. So that's something to factor in. The courthouse is free, at least relatively speaking. Um, Interview the arbitrator. Here's something you can do. You're considering an arbitrator. You can call the arbitrator up and you can ask that person, have you arbitrated lots of cases like this? What's your experience? Can you recommend other lawyers you've arbitrated in front of? Some of them won't do it. Some of them will do it with the proviso that they'll only do it if the other side's lawyer's on the phone, which is it's a good point. I get that. But you can kind of get a feel for what the person really is like. Most arbitrators, their bios, like most lawyers, say we do lots of different things. But really, my bio says I've done all these different things, but really there's 3 or 4 that are my bread and butter. And you can get a feel for what the bread and butter of your arbitrator is. So anyway, it's something to think about. Next slide, please. Okay, so then the arbitration comes along. You've gone to arbitration. You've called your witnesses, cross-examined them. You've had arguments. You've had something at the end has happened, either a closing argument while you're there or post-arbitration briefs. Personally, I'm not a big fan of post-arbitration briefs because they take a lot of time. They're very expensive. if the arbitration is not that long, just do a closing argument. If you want, remember, we are in arbitration because we think it's faster, it's cheaper, it's streamlined, then let's get to it. We only spent 4 days here in the arbitration. Let's give a closing argument and have the arbitrator rule. Now, having said that, most of us lawyers like to have the comfort of hammering that nail one more time. We made the arguments, we called the witnesses. We still want to have post-arbitration briefs, but those are very costly. So each side does a brief. Then each side has to do a response to the other side's brief. Maybe there's a third level of reply. Now it's tens of thousands of dollars just for the closing argument briefs. And then some judges want to have a closing argument after that, some arbitrators. There are cases where that is warranted. If it's a very complicated case, especially if there's a lot of numbers, those are tough to keep track of, even for the most seasoned arbitrators. So maybe you want to have a brief, but I would just caution everybody, just do a closing argument. It's worked perfectly. You don't do closing argument, you don't do closing briefs for a jury. They've been sitting there paying attention, hopefully, just like the arbitrator's been paying attention, hopefully, for a week, 2 weeks. Just do the closing argument and then abide by the result. Here's the problem with arbitration, though. Appellate rights. There is almost no right to appeal. There's every now and then you'll see a decision where a court will say an arbitrator manifestly disregarded the rules or otherwise. And even then, the appellate court or the court trying to enforce the arbitration result will almost always find no harm, no foul. The number of arbitrations that get reversed by a court are very slim. I try to keep track of these things. I read as much as I can, and again, with the proviso that a lot of them you don't hear much about. But if someone's appealing it, it's in the court system, those get reported, and it is a minuscule percentage. Let's go to the next slide, please. These are quotes from real courts upholding arbitration results. An arbitration result should be upheld even if not totally unsupported by general legal principles. Even if it resulted in a substantial injustice, it still is going to be affirmed because that's the arbitration system. We're asking for certainty. We're asking for finality. Next page, please. A court cannot set aside an arbitrator's error of law, no matter how egregious. That's from a reported decision. An arbitration award that incorrectly interprets the law has not manifestly disregarded it. It has simply made a legal mistake. To manifestly disregard the law, one must be conscious of the law and deliberately ignore it. So as you can see, the courts are bending over backwards to make certain that arbitration really is final, not endless appeals like you get in the court system. So let's go to the next, please. So there are still some limited areas where people do appeal somewhat successfully. And I mentioned this 3 or 4 times now, where the arbitrator excludes evidence. That could be good or bad. If you want to give the other side appellate grounds, have the arbitrator exclude a lot of evidence. That's one of the only parts of the Federal Arbitration Act that gives grounds to appeal. So in other words, they've just got to let it all in. The other one is undisclosed conflicts of interest. That is still an area where you see some appeals. Unfortunately, though, most of the opinions coming out say they still find no harm, no foul. Yes, the arbitrator could have disclosed the fact that their son works for the defendant, that kind of thing. But, if the other side had done a little better research, they would have found that out. Therefore, no harm, no foul. So there are very few grounds to appeal. Let's go to the next page, please. So it's our California Supreme Court. Why do we allow arbitrators to get it wrong when we don't usually allow judges and juries as much latitude? Again, arbitrators Most of them are great. Even the great ones make a mistake now and then. We all do. The courts have held that when a mistake is made, the arbitration award should still be affirmed because it vindicates the intentions of the parties that the award be final. And because an arbitrator is not constrained to decide according to the law. Arbitrators, this could be a good thing. They're not stuck in the box of what a jury instruction might say. When I try cases in front of a jury, I blow the jury instructions up. I tell the jury, you have to rule this way because this jury instruction says it right here. It says this is what the ruling must be if this kind of evidence is provided. Arbitrators, they sit in equity, as people like to say. They can try to find a fair result, even if not technically within the law. Okay, so I've been talking for a while, so we're going to show a little video clip in a moment. Now, I actually have a point to the clip, but also I realize you've been looking at me for 45 minutes. That's too long. So next, please. Are you able to press play on that one? Ash, if it's not working, let's just go to the next one. Okay, if we can. There should be a play button, but if not, all right, we're not going to see it. Anyway, actually, let's just go back to that last screen, even if it doesn't work. So in this movie, it's called No Country for Old Men. It's a great movie, Academy Award winner. Javier Bardem is this psychopath that keeps going around and he keeps flipping coins with people. He will feel aggrieved by someone, so he'll flip a coin, and depending on how they call it, they'll either live or it won't go so well. And anyway, great movie. But the point of the scene is just because it's faster, it's cheaper, it's streamlined, and it's final. But that doesn't mean every grievance should be adjudicated by something just because it's faster, cheaper, and final, as it is in the movies. So anyway, let's go to the next slide, please. So I'm going to talk about some cases now where arbitrators have something has happened, something unexpected had happened. It may be someone's fault. It might not be anyone's fault. It just happened. And lest you're thinking, well, sure, he Googled for hours trying to find an arbitration where something funny happened. The next three I'm going to tell you are three my own cases I've had in the last 18 months where something funny happened, and I kind of wished I was in the court system. The first one, it was a particular type of case. I'm going to be very vague on the details for reasons that'll be obvious. There was a contract between the parties. It said arbitration had to be concluded within 6 months. We found a well-respected arbitrator who agreed to do it within 6 months. The arbitrator ran a tight ship. We did get the hearing done, everything done, discovery. Each side got, I think, 2 depositions, and then like 5 months and 27 days into it, we gave closing arguments late on a Saturday night. Arbitrator agreed to have the ruling out in 3 days, so everything would be done in 6 months as provided for the contract. And then nobody heard anything from the arbitrator for 4 months. Couldn't find him. Ruling didn't come out. And then it came out 4 months later, and it kind of looked like somebody had tried to piece it together 4 months later. And it was very disappointing. And there's really very little we could do. There's no grounds to appeal on those grounds. There's no grounds to appeal on hardly any grounds we've talked about. So we didn't get it done in time. Both sides were frustrated, and that's just the way it goes. I mean, there was no other presiding judge to go to make it happen otherwise. Here's another case. I have a Ninth Circuit oral argument coming up. I represent a client who had an arbitration in China. The arbitration in China, the arbitrator awarded the other side $50 million US dollars. During the 2-hour arbitration, that's all it was for a case with that kind of money. The arbitrator, while the screen was on, was in the bathroom, was talking on the phone, got into a taxi cab, then got into a train car with his kids and his wife, and was talking to them while the camera's on, supposedly paying attention. Then comes out with a ruling like that against our client. The other side appealed to a court in Hong Kong. That court was so infuriated, they threw the arbitration award out in China and ordered the other side to pay our client attorney's fees. However, the other side then came to federal district court here in California, and the federal district court judge affirmed it, and now we're up on the Ninth Circuit. The arbitrator was not engaged, was not paying attention, and we might win this one. But boy, that's about how egregious the facts have to be to get the arbitration thrown out. Another one, this is just another twist. I had another arbitration. It was by contract. We have the arbitration. It goes 2 weeks. Things seem to go pretty well. And then I get a bill after the arbitration for, I won't, dozens and dozens of hours of a clerk who was not present at the arbitration, reading the transcript and assisting with writing the award. Nobody agreed to pay these charges. And I raised it with the service when they said the award, they said the award's ready and sent us the bill. There's all this time for someone, nobody agreed to. I told this service, I'd like to talk to someone about the bill. I mean, this is tens of thousands of dollars more than we expected. And I was told you're not going to get your award until you pay it. So, and I said, well, what if we don't pay it? And you never get your award. So what do we do then? So these are all situations that wouldn't come up in the courthouse. They're atypical. Most arbitrations run smoothly. We don't have any of the problems we described here. But if something does happen, not a lot you can do. Our hands are tied. I'll give you one more example. This wasn't a case I had, but a buddy, a great trial lawyer I've tried a couple of cases against in the Midwest. He was on arbitration, and they were playing 2 hours of an expert's deposition transcript. And they wanted to make sure the arbitrator was paying attention to the expert's testimony. So everyone had their cameras on while they were just watching a video. During that time, my friend and opposing lawyer both saw the arbitrator walk in the background to the refrigerator and get a beer out 3 different times, and then came back. I guess he didn't think his camera was on and drank the 3 beers there. So again, you know, I know judges in the courthouse aren't perfect either. Nobody's perfect, but there are funny things can happen in the courthouse, and you have remedies. Not so much can not so many remedies when those things happen in arbitration. So let's go to the next one, please. So is it faster? Is it cheaper? So let me conclude by saying usually. I'm still a big fan of arbitration. It usually is faster. It's usually cheaper. It's definitely more streamlined. It's definitely more final. There's subject matter expertise, which comes in handy a lot. And some kinds of arbitrations can be confidential. So I would still say arbitration is a great place for many types of disputes, but not all. So I've encouraged people to think through what kinds of things you think might come up in going forward, whether you really want to be in arbitration for them or be in the courthouse. And if you do want to be in arbitration, make sure you have the provisions in your contract that provide some sort of guidance, some sort of guardrails. There's only this many depositions. There's only this much document discovery. Each side only gets 5 interrogatories or something. So it's not completely full blown. Because if you have full-blown discovery and all that in arbitration, you can still do it. There are still some benefits, but I'd kind of rather be in court where there are remedies and rules. So we're coming up on time. I'll give you just one more. I'll give you slide one more slide, please. And then if there are any questions, why don't we go to the next one? One more. Other options, if you just really don't like jurors, you could always agree that there will be no jury. You can stipulate to that. Now, California and Georgia, I believe, have rules about that, who say you cannot stipulate to a court trial without a jury, which I find curious, because you can stipulate without a jury. They say it's waiving the constitutional right to a jury, but you're also waiving it when you go to arbitration. But those two states seem to be outliers. Everywhere else seems to allow you can just stipulate court trial, no jury, and waive the jury. So let me just while we're talking about the juries, I'll just stick up with the jury a little longer. I appreciate the people who sit on my juries. They haven't always ruled in my favor, but whether they've ruled in my favor or not, I've appreciated the fact they showed up for jury duty. A lot of people don't. They sat there and paid attention. And I will say early in my career, I lost a couple trials and I blame the jury. Those dumb jurors, they didn't understand my case. It was way above their heads. Well, whose fault was that? That was my fault. That was my fault. They didn't understand the case. So they're there doing their best. It's my job to make it understandable. And that same mantra applies for arbitration. The most knowledgeable arbitrator who's paying the best attention and putting the most thought into it still doesn't know everything about my case. I need to make things understandable. And if they're not understandable to an arbitrator or a jury, that's my fault. So the difference, though, with jurors make a big mistake. The judge can grant a new trial. The judge can take a red pen and fix the verdict. If that doesn't happen, the appellate court can do the same things, or they can order a new trial, and we can get it right that time. Those are remedies that are not available in arbitration, and that can be a good thing, that can be a bad thing. It just adds more and more cost the more and more appeals you have, but it also gives some safeguards, because a runaway jury verdict, there are remedies. A runaway arbitration verdict, not so much. So there are some lengthy questions here about what should go into arbitration provisions, and I think they're probably a little more. It's going to take more than the time that I have left. Here's what I would do. I'm going to conclude here in a moment, and if there are any further questions, great. But if I don't get to your question, feel free to email me. It's jswarden@venable.com. You can email me. Happy to talk to you about it. We could have a Zoom or something if you want to talk, if it's more nuanced. I don't know all the answers, but I know some of them. And I don't draft the arbitration provisions usually. Sometimes I'm asked for input, and I give the input I've given now. Lots of times the arbitration has been filed, or we're filing it, and there's a provision there, and sometimes the provisions are great. Sometimes I wish they'd be a little different. It just depends. But anyway, I don't want to leave anyone hanging if I didn't get to your question. Any further questions? I'll give it a couple more seconds. All right. Otherwise, I think I got to the ones other than the specifics of how to draft. And those I'd be happy to discuss. Let me just remind everybody, arbitration CLE code is Arbitration 2025. Arbitration 2025. And Ashton, unless we have something further, that's all I have to say. Thank you.